The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain child custody and parenting rights for unmarried fathers in Illinois. So, the first step to getting any parenting rights at all is to establish paternity. Even if you're the biological father, unless you've established paternity, you have no right to access the child and no right to any parenting time or responsibility. There's a couple different ways to establish paternity. The easiest is to sign a voluntary acknowledgement of paternity form at the birth of the child. This is usually provided by the hospital. If you do this, you can be added to the child's birth certificate, and it's a very simple process. If you don't do it near in time to the birth of the child, then you can still establish paternity by agreement with the mother of the child after the fact. You'll have to file a petition in court to do this, but it's still a very simple and easy process. If there's a dispute as to paternity, again, you file a petition with the court to establish paternity, but there will be a hearing at which both sides will present evidence for and against the alleged father's paternity. And that evidence usually takes the form of DNA testing and expert testimony analyzing the DNA test results. At the end of the trial, the court will either establish paternity or decide that that person is not the father. If paternity is established, then at that point, the father can be added to the birth certificate of the child, even if the mother continues to object. So what does it mean to have paternity established? What rights does that give you? Well, it doesn't automatically give you any rights. It automatically gives you a financial obligation to support the child in the form of child support, but it doesn't confer any parenting time or responsibility upon you. It doesn't give you any access to the child just because paternity has been established. In order to do that, either in the same proceeding or in a separate proceeding, you have to have a hearing to establish parenting time and responsibility. Now, let's talk about how this is accomplished. This can either be done through a parenting agreement that the court approves, and that's the best way to do it because it's something that the parties will have to live with, and parenting agreements that are negotiated rather than ordered by the court tend to be easier for the parties to actually execute over the coming years. It also reduces the amount of tension and strain between the parties as they try to co-parent together. If you're not able to agree on all the terms of a parenting agreement, the court will order mediation, at which point a third-party neutral trained mediator will try to help you come to a settlement agreement and finally come up with your full joint parenting agreement. If you're not able to come up with a parenting agreement after mediation, then the court will typically appoint a guardian ad litem, which is a family law attorney who will investigate the best interests of the child and report to the court as to recommendations regarding parenting time and responsibility. And then there will be a hearing at which both parties make an argument and present evidence, and the guardian ad litem makes his or her recommendation about the best interests of the child. And so let's talk about how courts determine parenting time for unwed fathers if there is a hearing. If there's not a hearing, if it's all done by agreement, then it doesn't matter what the court determines. They just have to approve the agreement. But if there is a hearing, here's the process and what courts use to determine how to allocate parenting time and responsibility. The standard and rule of thumb is the courts are trying to come up with a parenting arrangement that is in the best interest of the child, and that is a term of art. And courts use a number of factors that we detail in the article associated with this video to determine the best interest of the child. And you can find that article at learn-about-law.com. But the bottom line is they'll look at all of the facts and try to determine what's going to be the healthiest situation for the child. And all things being equal, they will try to give equal parenting time or roughly equal parenting time to both parents, even unmarried parents. Theoretically, the law is genderless, so there's not supposed to be a preference for the mother as opposed to the father. But unwed fathers still face an uphill battle in getting the majority of parenting time or primary residency. And this is because of something called the primary caretaker presumption. The primary caretaker presumption causes the courts to presume that it is in the best interest of the child to continue to primarily reside with the person who has been their primary caregiver up to this point. And for unmarried couples, this is almost always the mother. It tends to be that situation. There are situations where the father is the primary caregiver, and in those situations, the primary caregiver presumption will favor the father. But this is only one of the many factors that courts use to determine the best interest of the child. So the father has the opportunity to show that based on the other factors involved, that it's actually in the best interest of the child for the father to be the primary residence of the child. Now, again, it's an uphill battle, but the father still has the opportunity to an equal playing field to show that despite the fact that the mother is the primary caregiver, it's still in the best interest of the child to reside with the father. A couple of things to note here is that the inquiry is always very fact specific. So there's no hard and fast rules that, the mother is going to necessarily be the primary residence of the child. It's based on the situation of the case and what the court finds to be in the child's best interest. So the father does have a voice here. The other thing to note is that even though it is an uphill battle due to the primary caregiver presumption for an unwed father, all things being equal, again, the court tries to divide parenting time roughly equally because it tends to be in the best interest of the child to have both parents very involved in their life. So as long as there's no reason not to divide parenting time equally, that's probably what the court will do. It just becomes a challenge to get the majority of parenting time to the father. Now, something we should talk about here in wrapping up is a lot of people talk about child custody and visitation, trying to get sole custody of the child. That's still, getting sole custody of the child is still a thing in Illinois, but in 2016, the terms custody and visitation were changed to parenting time and responsibility, and that's why we've been talking in those terms. And rather than being a binary choice between one parent having custody and the other parent having visitation, it's a sliding scale of how much time and responsibility each parent has for the child. So it can be more of a middle ground, and it's not a fight. The law change was intended to reduce fights over who has custody and find a fair parenting agreement that gets both parents involved in the child's life. And this tends to be a good thing for unmarried fathers because it's not a win or lose situation. It's generally a roughly equal parenting time, and it's a sliding scale. So if there's reasons not to have equal parenting time, it's not necessarily that the mother has custody and the father just gets visitation rights. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, or our email database, which you can do on our website, learn-about-law.com, and you'll be notified of our daily article and video posts. If you found this helpful and you would like some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.